In March 2018, a small logistics company based in Atlanta received a call from their bank. The caller informed them that their primary business account, the one used for payroll, vendor payments, and operating expenses, had been emptied 3 days earlier. The balance at the time of the transfer, $340,000. The authorized signatory on the transfer, one of the two founding partners. The other partner, the one receiving this phone call, had no knowledge it had happened. By the time the call ended, the partner who initiated the transfer had stopped responding to calls, emails, and messages. His personal belongings had been removed from the office 2 days prior. He was not heard from again for 11 months. This is the full account of what happened, what the legal process uncovered, and what the partnership agreement, the document that should have prevented all of it, actually said. To understand how this was possible, you need to understand how most small business partnerships are structured, and more specifically, how most of them are not. A business partnership, in its simplest legal form, is an agreement between two or more parties to operate a business together. That agreement, the partnership agreement or operating agreement depending on the entity structure, is supposed to define everything. Who controls what? Who can authorize what? What happens when one partner wants to leave? What happens when one partner acts unilaterally? In practice, most small business partnerships are formed on trust, momentum, and a handshake understanding of roles. The legal document, if it exists at all, is a template downloaded from the internet and signed without being read carefully. That gap between what the agreement says and what the partners assumed it meant is where this case began. The two partners in this case, we will call them Marcus and David, had been friends for 11 years before starting the business together in 2014. The company grew steadily. By 2017, they had 18 employees and approximately $2.1 million in annual revenue. Their partnership agreement gave both partners equal signatory authority over all company accounts. No dual authorization requirement. No transaction limit requiring joint approval. Either partner could move any amount of money at any time without notifying the other. That clause, standard in many template agreements, was the single condition that made everything that followed possible. What happened next unfolded in 3 stages. Stage 1. The transfer. David initiated a wire transfer of $340,000 from the company's primary operating account to a personal account he had opened 6 weeks earlier at a different bank. The transfer was processed without issue because he had full legal signatory authority to initiate it. He did not notify Marcus. He did not notify the company's accountant. He did not leave a note, a message, or any documentation explaining the movement of funds. 3 days later, when payroll was due, Marcus attempted to process payments and discovered the account balance was insufficient to cover them. Stage 2. The disappearance. By the time Marcus reached the bank and confirmed the transfer, David was unreachable. His phone went to voicemail. His email auto-reply indicated he was unavailable. His apartment, which Marcus visited in person, had been vacated. Marcus filed a police report within 48 hours. The responding officers informed him that because David had legal signatory authority over the account, the transfer did not constitute theft under criminal statutes in their jurisdiction. It was a civil matter. That distinction between criminal theft and civil misappropriation is one of the most consequential and least understood boundaries in business law. And it is the reason David was not immediately arrested. Stage 3. The collapse. Without the operating account balance, Marcus could not process payroll. 3 employees resigned within the first week. 2 major clients, notified of the payroll failure through the employees who left, terminated their contracts citing concerns about the company's financial stability. Within 60 days of the transfer, The company had lost 40% of its workforce and 60% of its contracted revenue. Marcus filed a civil lawsuit against David within 30 days of the transfer. The lawsuit alleged breach of fiduciary duty, conversion, and unjust enrichment. Breach of fiduciary duty is the legal claim that a partner, who owes a duty of loyalty and good faith to the partnership, acted against the interests of that partnership for personal gain. Conversion is the civil equivalent of theft. It applies when one party wrongfully takes or uses property belonging to another. In this case, the argument was that while David had signatory authority over the account, the funds themselves belonged to the partnership, not to him personally. Unjust enrichment is the claim that David benefited financially at Marcus's expense in a way that was inequitable and legally unsupportable. All three claims were filed simultaneously. The civil case moved forward without David present. He had not yet been located. David was located 11 months after the transfer, in a different state, under his own name, working for a mid-size freight company. He had not attempted to conceal his identity. When located, he was served with the civil lawsuit. He did not retain an attorney immediately. He did not respond to the initial filing within the required time frame. As a result, Marcus's attorney filed for a default judgment, a legal mechanism that allows a court to rule in favor of the plaintiff when the defendant fails to respond. The court granted the default judgment in full. David now owed Marcus and the partnership $340,000 plus legal fees and interest. Collecting on that judgment is a separate process entirely, and the one that takes the longest. A judgment is not a payment. It is a legal finding that the debt exists. Collecting it requires locating assets, garnishing wages, or placing liens on property. In David's case, collection proceedings began immediately upon the default judgment being granted. Over the following 18 months, Marcus recovered approximately $190,000 through wage garnishment and the liquidation of a vehicle David owned. The remaining $150,000 remained outstanding at the time of the last court filing available in the public record. The company did not survive. Marcus formally dissolved it 14 months after the transfer, citing irrecoverable client and revenue loss. What this case demonstrates, and what makes it instructive beyond the specific facts, is that the legal mechanism that allowed David to transfer the funds was not a loophole. It was a clause both partners agreed to and neither fully considered. The dual authorization requirement, a provision requiring both partners to approve any transaction above a defined threshold, is a standard protective clause that was absent from their agreement. Had that clause existed, the transfer would have required Marcus's approval. It would not have been processed. Three protective clauses every partnership agreement should contain. 1. Dual authorization for transactions above a defined threshold. Both partners must approve any transfer above a set amount, typically $5,000 to $10,000 for small businesses. 2. A buyout provision defines what happens to a departing partner's ownership stake, how it is valued, who can purchase it, and on what timeline. 3. A dispute resolution clause requires partners to attempt mediation before litigation, reduces legal costs, and preserves the possibility of resolution without court involvement. None of these clauses are complex. None require a law degree to understand. They are standard provisions that any business attorney can draft in a single session. The cost of adding them to a partnership agreement, a few $100s. The cost of their absence, in this case, a company, 11 years of friendship, and $340,000. In the next video, we break down exactly how operating agreements determine what happens to a business when a partner exits, voluntarily or otherwise. This is verdict paper. Every collapse has a paper trail.